behalf of the appellant, Mr. Andrew Tittle, and I'd like to reserve 4 minutes for rebuttal.
Very good.
Your Honors, this is a divorce case from Williamson County Chancery Court. It's stemming from an 8-year marriage involving one child. This trial was held in July of last year on the 6th, 8th, and 18th, and the order was entered on August the 19th. The memorandum in order awarded the wife, Ms. Tittle, a divorce on the grounds of inappropriate marital conduct stemming from what the court deemed financial duplicity and an abuse of beverage alcohol by the husband. Ms. Tittle was also awarded a greater allocation of the marital assets, 61.21% versus 38.79%. And Ms. Tittle was awarded alimony in solito of $50,000 taken from husband's allocation, as well as transitional alimony consisting of $2,000 per month for 48 months, $1,500 per month for 24 months, $1,000 a month for 24 months, and $500 per month for 24 months for a total duration of alimony of 10 years. Finally, Ms. Tittle was awarded attorney's fees in the amount of $75,000 as alimony in solito that was payable in 5 installments of $15,000 beginning on the September 1st of 2023 and on September 1st of each their year after. This appeal raises 4 issues for the court's consideration. However, we're only going to be focusing on 3 of those issues today. I want to point out that issue number 3 that was raised in our appeal involves the allocation of work-related child care and between the parties, because on the parenting plan it stated that under J other that Mr. Tittle was responsible for the entirety of the approximately $1,600 for child care. However, the child support worksheet allocated a portion of that between the parties. Elsewhere in the memorandum, the court did address that, I believe on page 36 of the memorandum, and did allocate that amount between the parties, roughly $300 to the wife and $1,317 to Mr. Tittle. So that issue we were not going to be focusing on today.
But you're still assert that that was a mathematical error.
I assert that the allocation of the child care was not considered when determining the award of alimony elsewhere.
Okay.
So I think that the parenting plan stated 2 different things, and that he wasn't properly credited. However, the court addressed that elsewhere in the memorandum, so I believe that those credits are correct.
Okay.
Okay, so that's not a live issue for us.
Correct, Your Honor.
Okay.
So the remaining issues that we will be discussing today is 1, whether the trial court erred in finding that the plaintiff suffered untreated alcohol addiction despite there being no credible evidence supporting this conclusion. 2, whether the trial court erred in the amount and duration of transitional alimony and the amount of alimony in solito awarded to the defendant, and whether the trial court failed to properly consider both the plaintiff's ability to pay and the defendant's need. And then whether the trial court erred in awarding attorney's fees to the defendant and whether the amount of the attorney's fees was proper. On the first issue regarding the finding of alcohol abuse as a ground to support inappropriate marital conduct, there was a lot of testimony in this matter regarding Mr. Tittle's alcohol consumption. And specifically, when the parties met in 2011, Mr. Tittle was serving probation stemming from a conviction of vehicular manslaughter, yes, Your Honor. And that resulted in the death of his friend. Ms. Tittle met him while he was going through the probation program, and I believe that she was actually involved in some capacity in that program. But regardless, she was aware of that when the 2 of them met. Mr. Tittle did not consume alcohol. The testimony showed that he did not consume alcohol during the duration of his probation, but following his probation that he later did begin consuming alcohol prior to the marriage of the parties, and that in fact the parties consumed alcohol together at times. Following the birth of the child, it was testified that his alcohol consumption increased to the point where he was drinking, I believe, between 2 and 4 beers, alcoholic beers per day. The testimony that was shown was, I believe, from a mutual friend of the parties, a Michael Bird, who said that he drank with them on occasion, saw both of them drink to the point of intoxication prior to the birth of the child, but after that did not see the wife consume alcohol or did not see Mr. Tittle consume to the point of intoxication. The other person that gave testimony was the sister-in-law of Ms. Tittle, who testified about Mr. Tittle, drinking in excess on vacation and I believe wanting to drive. However, there was only one example that was given. It was about wanting to buy a growler of beer while on vacation. There was no testimony that he actually drove while intoxicated, and it was later shown that Miss Deyoung, who was the sister-in-law, had not interacted with Mr. Tittle or seen him since 2020, a year before the divorce was filed and roughly 2 years before this testimony was given. A lot of this centered on one day, and that's February 28th of 2021, and that was where Mr. Tittle had been drinking with the mutual friend, Mr. Bird.
The wife's birthday.
Yes, Your Honor. Came home, she said that he was intoxicated, he was trying to assist with putting the child down, she said that he was interfering with that. And from there, from that testimony, the court found that Mr. Tittle routinely drinks several beers every day and often drinks to the point of intoxication. There was no testimony saying that he drank to the point of intoxication with regularity, and there was no, the testimony was that he consumed, I think, a few beers each day.
If the court were to agree with you that the evidence preponderates against a finding that he had an alcohol problem, what relief are you seeking?
Your Honor, I think just that finding reverberates through the entirety of this order. It's later used when determining the division of the assets. It's later used when determining custody and when it's and determining the allocation of, or the award of alimony. And specifically that he has an untreated alcohol abuse disorder is what the court found. And the testimony and the evidence that was submitted and provided at trial does not support that finding. I don't necessarily know that that goes to, the court can award the divorce on the grounds of inappropriate marital conduct on any other grounds, or even that one, consuming alcohol.
The court, one of the bases of the inappropriate marital conduct was financial chicanery.
Yes, Your Honor.
Or what have you, and that's not even briefed.
Correct, Your Honor.
So
understanding that it's not necessarily overturning the award of the divorce, it's more so that finding of the untreated alcohol abuse disorder reverberates through this ruling and affected the division of marital assets. It was at least considered in the custody, which we did not appeal the parenting plan, and the award of alimony, it was one of the factors that was considered. Issue number 2, and getting more to the meat of the matter, is the award of transitional alimony and the weighing of Mr. Tittle's ability to pay and Ms. Tittle's need. Now, the statute 36-5-121 set forth several factors that a court is to weigh when awarding alimony, but the biggest two are need versus ability to pay. And in determining that, first, the court divided the parties' marital assets 61% and I think 61.25 and 38.75 roughly. From that, the court awarded Ms. Tittle alimony and solido of $50,000 from the husband's share. And the justification for that was that it would reduce her need for support long term. And again, this is an 8-year marriage. Even though that was done to mitigate the need for long-term alimony, the court awarded transitional alimony for 10 years, a period longer than the marriage itself. The court awarded transitional alimony of $2,000 for 48, as previously stated, 48 months, $1,500 for 24 months, $1,000 for 24 months, $500 for 24 months, total of 10 years. For need, the court found that Ms. Tittle's income was $2,503.20, and that her expenses were $5,272.86. That resulted in a deficit of $3,225.66 per month. After applying child support, which was $1,190, her need reduced to $2,035.66. Although the court stated, it appears that the court added that in the actual order, saying that her need was $4,539.86. For Mr. Tittle's ability to pay, the court found that his gross annual income was $158,700. Then, after taking out expenses, the court found that his net monthly income was $9,033. The court then subtracted the child support, $1,190, Mr. Tittle's monthly expenses, $5,660, and did not include the payments that would be made on the Chase credit card, leaving Mr. Tittle, per the court's order, $2,183 net of those with which to pay support. But what the court did not include in this was the allocation of the work-related child care, $1,317. From that, Mr. Tittle had $866 with which to pay support. When you subtract $2,000 out of that for the first 48 months, that's a deficit of $1,134 for the first 48, $634 for the next 24, $134, and finally he would get a surplus of $366. That leaves roughly $72,000 of deficit that Mr. Tittle is during the duration of the alimony. Finally, the award of attorney's fees was alimony in solito. That's paid out $15,000 over 5 years, $75,000, $15,000 a year over 5 years. That's roughly $1,250 per month during that time. That's a further deficit during that time. So the total that Mr. Tittle was left in deficit during the length of the alimony period was approximately, I believe, $135,000, give or take. In our brief, it included this. We did it based on the $1,600. However, there it does need to be roughly a $30,000 adjustment on the total life of it because of the $300 that goes back in.
I'm sorry, say that again.
Yes, Your Honor, I'm sorry.
I'm lost you.
Yes, Your Honor. In our brief, we had done our calculations based on Mr. Tittle paying the $1,600 for work-related child care, and that's where our calculations of the deficit came from. However, when recalculating with the $1,317 that he's actually responsible for, that leaves the overall deficit over the life, without counting the attorney's fees, of approximately $72,000 is the deficit over that 10-year period. When you factor in the attorney's fees during that time, that is paid in during the deficit period. So that's an additional $75,000 of deficit during that time, with which the trial court ordered Mr. Tittle to pay support. That's an illogical result, and it's an injustice on Mr. Tittle because he is operating at per the court's finding of his ability to pay, the court is setting him at more than negative $2,000 per month for the duration of this period. Thank you, Your Honor.
All right, thank you, Mr. Coleman. Ms. Perkey, good afternoon.
Honors. Sarah Richter Perkey. I represent the appellee, Deidre Tittle. May it please the court. I'll first address the alimony issue that appears to be the most significant issue in the briefs. Mr. Tittle first claims that the award of alimony to Ms. Tittle exceeded her need. It's undisputed that she had a monthly need of $2,053 per month after taking into account her employment as a nurse tech and subtracting her child support award. Now, the court awarded Ms. Tittle $2,000 a month for 48 months, which would have been $35 less per month than her stated need. The court then awarded her $1,500 for 24 months, which would be $535 less than her stated need, and then $500 a month for 24 months, which would be $1,535 less than her stated need. As such, the court awarded Ms. Tittle $67,000 less than her stated need over the term of the alimony award. However, the trial court correctly addressed this deficit by awarding her an additional $50,000 in alimony in solito, and that was to address this shortfall. However, this still left her with a deficit of $26,000 over the life of the term of the alimony. As such, the court did not, in fact, award Ms. Tittle more than what was her stated need. Now, addressing Mr. Tittle's ability to pay. The court determined that Mr. Tittle's net income was not $7,843 after the payment of child support to Ms. Tittle. Now, if you deduct his expenses of $5,660, he has a surplus of $2,183 per month. Now, he has maintained in his brief that he doesn't have the ability to pay this award because he had to pay 100% of the cost of work-related child care. Now, it appears that Mr. Tittle has conceded today that, in fact, he is not responsible for 100%, but instead that cost is shared pro rata. As such, both parties have, he has a little less of it, he has less expenses, she has a little bit more. So she has to pay $307 in addition to what was stated on her income and expense statement. This allocation leaves Mr. Tittle with a deficit of $1,134 per month after the payment of the ordered alimony award, and Ms. Tittle with a deficit of $143 a month. However, this deficit is short-lived, Your Honors, because the minor child in the proof showed, and it's in the record, that the minor child is expected and did in fact begin kindergarten in August of this year. As such, this work-related child care of $1,627 goes away. And when that happens, Ms. Tittle continues to operate at a deficit. She'll operate at a deficit of between $35 a month and $1,535 per month throughout the tenure of the alimony, whereas Mr. Tittle will be operating in a surplus of $183 per month to $1,683 per month, assuming that the parties' incomes remain stagnant during this period of time. Now, as the court is well aware, the two most important factors in determining an alimony award are need and ability to pay. However, the threshold consideration is the recipient's need, and the case law supports this in Tennessee. Here, as in most divorce cases, the parties will both struggle financially post-divorce because, as the court is well aware, it takes more money to operate two households than it costs to operate one household. But as the court very clearly explained in its order, Ms. Tittle is the party who is faced with making, and I think this is the language that the court used, substantially greater financial adjustments to her life than Mr. Tittle. And this is reflected in the alimony award, Your Honors. Because this alimony award is less than Ms. Tittle's need and leaves Mr. Tittle with a slight deficit for only 1 year that is already passed, this discretionary decision of the trial court should be affirmed. I would like to now talk about the attorney's fees. Mr. Tittle contends that the trial court erred in awarding Ms. Tittle a portion of her fees. As the court is aware, an award of attorney's fees in a divorce matter is a discretionary decision and also acts as a form of alimony. Now, the court did in fact engage in an exhaustive analysis of the factors under 35-6-121 as it was required to do. But the court also went on to explain that it considered Mr. Tittle's unnecessary litigiousness as well as his financial dishonesty that was pervasive throughout from the beginning of the filing of this complaint for divorce all the way through the end. And the court specifically found that this financial duplicity had unnecessarily increased the cost of litigation and prolonged the proceedings. Mr. Tittle has said that he does not have the financial ability to pay these fees. However, as we've already discussed, he will be operating at a surplus every month now that the minor child has begun kindergarten. In addition, Mr. Tittle received over $90,000 in liquid assets from the marital estate and from which to pay this award of attorney's fees over the next 5 years. I also think it's really important for the court to remember that Mr. Tittle created these circumstances himself. It should not be Ms. Tittle who has to deplete her share of the marital estate to pay for Mr. Tittle's dishonesty and litigiousness. this court has held many times that an award of attorney's fees is appropriate in spite of a litigant's inability to pay them when the proof shows that that litigant had exhibited misconduct which increased the cost of litigation, which is exactly what our trial court found in this case. In addition, the court has made a similar finding when the fees were incurred in relation to a custody proceeding or a support proceeding, which is also what we have in this case. As such, Your Honors, we are requesting this discretionary decision of the trial court be affirmed. With respect,
the husband's counsel is saying we should consider whether the trial court erred in finding an alcohol abuse in relation to the various alimony awards in the division of the property. What do you say in that regard?
Your Honors, I mean, I feel like it was very confusing that this issue was even briefed, because they don't really request any relief in their brief if in fact that the court found that there was not support for this finding, what they want as a result of it. I would say that they do not argue and they do not contest that in fact Mr. Tittle is at fault for the demise of the marriage. And so that's really the factor that we're talking about. Underneath the alimony statute, fault is the consideration, right? But he's not saying that he was not guilty of financial duplicity. He makes no contest to that. So I'm not really sure what the significance of this argument is at all. And that kind of goes back to our argument about fees on appeal. I'm happy to address, if the court, I've got a little bit of time, just to kind of talk about what proof supported this finding by the trial court as to fault. As counsel for Mr. Tittle said, Mr. Tittle was convicted of vehicular manslaughter due to intoxication prior to the party's marriage. As a result, as part of his probation, he participated in an alcohol and drug assessment. As part of that, he was instructed to abstain from the use of alcohol and to participate in a 12-step program. He did in fact do that, and he conceded at trial that in his participation in AA, he admitted that he was in fact an alcoholic. Despite this, Mr. Tittle continued to consume alcohol in increasing amounts during the marriage. He did admit to consuming 2 to 4 beers per night, but what he doesn't, counsel doesn't mention that these are high gravity beers. These are not a Bud Light or a Miller Lite. These are beers that have a very high alcohol content in them, and he's drinking them most nights. Mr. Tittle, the proof showed that he did in fact drink and drive on multiple occasions during the marriage when there were in fact other adults available to drive the vehicles and people who would offer to drive the vehicle, but he would almost fight them about wanting to drive the vehicle. He missed important events due to his choice to consume alcohol. He could not properly care for his child due to the consumption of alcohol. So clearly there's support in the record to sustain this finding by the trial court. Finally, Your Honors, I would like to address fees on appeal. This is the single issue that Ms. Tittle raises. In reviewing the record, it's abundantly clear that Mr. Tittle has used his vastly superior financial resources to harass, to intimidate, to financially abuse his wife. She earns $18.05 an hour as a nurse tech. Mr. Tittle has an engineering degree from Purdue, and he works for his father's company. I know that the trial court found that he made about $158,000 a year. There's plenty of proof to support that he made significantly more because he had the use of his father's credit card and a car and lots of other things that his father provided for him, an apartment, all kinds of things that could have also been added to his income. He has enormous resources available to him. He has pursued a number of frivolous claims on appeal, including a drafting error, which could have been easily corrected by filing a Rule 59 motion at the trial court, or even discussing with counsel and submitting an agreed order to amend the trial court's findings. He talks about a $1 Scrivener's error in the calculation of child support, which makes no difference to the child support calculation. He also, again, wants to negate this factual finding about the abuse of alcohol, which has absolutely no legal consequence to the issues before the court today. I submit, Your Honors, that this appeal was filed as a final attempt by Mr. Tittle to financially punish his wife. As such, we are requesting that she not be saddled with the financial burden of defending this appeal, and instead that Mr. Tittle be required to carry this due to his superior financial resources. Does the court have any questions?
I wanted to ask you one question about the attorney's fees awarded as alimony in Salito, and
Yes.
your discussion of cases that we've decided, we've said where there's bad actions in the court below, and we've said, you know, if it's increased the cost of litigation and divorce, so that's appropriate instance to award attorney's fees. But since Gonsuski, we still have to fit that within that framework, do we not? So we still have to have a affirmative finding from the court that the spouse seeking the award has demonstrated that he or she is financially unable to procure counsel, or they don't have the funds to pay counsel, and the other spouse has the ability to pay. I mean, we
Yes.
still have to fit it within that.
Yes.
Okay.
I agree, Your Honor, and there's proof for that. Ms. Tittle, the amount of fees that were awarded to her were her outstanding fees that she had not paid, and that she testified she did not have the ability to pay. She had paid most of her fees from loans from family members during the pendency of the divorce, or placed them on credit cards. And the proof also showed that Mr. Tittle received almost $90,000 in liquid assets, so he had plenty of resources available to him from which to pay the attorney fee award. Does the court have any other questions?
Hearing none, thank you, Ms. Perkey.
Thank you.
Mr. Coleman?
Thank you, Your Honor. First, I'd like to focus on the statement about the child care would end after 12 months. That is not contemplated anywhere in this order. And in fact, if the child care did end after that, then it would require a petition to modify child support to bring about a change in that event. Even if the deficit was short-lived, that still is leaving.
Well, isn't he to pay the child care provider? Isn't that
It's required that it's paid directly to the provider, yes, Your Honor.
okay, well, if there is no provider that sends him a bill, then he's not going to pay it.
That'd be correct, Your
He
Honor.
wouldn't need a court order to not pay a bill that doesn't exist.
Yes, Your Honor, but the amount of the child care is included on the child support worksheet such that it would be grounds for a modification of child support at that time. So
It would be.
in order to get that relief, then that would be it. And also, if the child...
Let me ask you,
Yes,
do you
Your Honor.
think the child support would be reduced, or would it increase because he's no longer paying the $1,600 or $1,300 a month in child care?
Your Honor, I can't say without running a worksheet on that. I think that it's possible that it could increase, but given the worksheet allocates that amount between the parties as it is based on their income shares. So when that portion is removed as an expense either way, I can't say that it would necessarily reduce his support. It could increase it.
And we're dealing with a modifiable transitional award too, are we not?
Yes, Your Honor. And the transitional amount, opposing counsels discussed that, after this first year, he would actually be at a excess. He wouldn't be exercising at a deficit because the child care would go away. But that doesn't take into account the award of attorney's fees, which is at $15,000 per year, and when broken down over the year, that's approximately $1,250 per month. So that is further reducing his ability to pay the support and increasing the deficit that exists. Ms. Tittle was awarded 61% of the marital estate. From Mr. Tittle's 38%, The court took $50,000 as alimony and solido lump sum prior to distribution, and then awarded an additional $75,000 alimony and solido over the course of years 2 through 6 following the divorce decree. And that's in addition to the $2,000 per month for 48 months, $1,500, $1,000, and $500. So all of that compounds together that, I believe it was stated that Ms. Tittle's need was, she was operating at a negative $100 or something deficit, but with Mr. Tittle's ability to pay, per what the court found, it's setting him at negative $2,000 for a period following the entry of this divorce.
What do we do with the fact that the court didn't calculate, but it did consider the fringe benefits that your client is receiving from the company credit card and the company automobile and what have you?
The court did consider that, and when saying that Mr. Tittle's gross income was $158,700, says that that is inclusive of income and fringe benefits. So the court did consider that. I believe that the testimony, Ms. Tittle sought to show that he earned in excess of $200,000. The court didn't find that. The court found that.
I didn't think the court monetized those benefits, but it.
Yes, Your Honor.
It mentioned them, but I don't know that it monetized them in calculating the $157,000.
Your Honor, I recall that there was extensive discussion in the order about that Ms. Tittle was saying it was this, and the court's only finding this. But when the court states this is Mr. Tittle's gross income for the annual income, it's inclusive of his income and fringe benefits are all inclusive in that $158,000, and the court so found that.
Okay. All right. Thank you.
Thank you, Your Honor.
All right. Thank you, Mr. Coleman and Ms. Perkey, for your arguments. We'll take this matter under advisement.
Thank you, Your Honor.
That concludes the docket.
All right.